Iluna, please rise. Ia ka'aha ho'okolo ki'i ke hano ua a koa ho'maila. This Honorable Supreme Court is now reconvened. Inoho ilalu, please be seated.
Please call the case.
Case number SCAP-22-0000557. Willie Kaupiko, Kaimi Kaupiko, Mike Nakachi for the Fishes Center for Biological Diversity in Kai Palawa Petitioners, Plaintiffs, Appellants, Cross Appellees versus Board of Land and Natural Resources, State of Hawaii, and Department of Land and Natural Resources, State of Hawaii, Respondents, Defendants, Appellees, Cross Appellants, and Pet Industry Joint Advisory Council, Respondent, Defendant, Intervenor, Appellee, Cross Appellee. Arguing for Plaintiffs, Appellants, Cross Appellees, Willie Kaupiko et al., Mahesh Cleveland. Also appearing is Isaac Morwake and Kyler Waker Cruz. Arguing for Defendant, Intervenor, Appellee, Cross Appellee, Pet Industry, Jeffrey Davis. Arguing for Defendants, Appellees, Cross Appellants, BLNR and DLNR, Melissa Goldman, Deputy Attorney General. Argument on the merits.
All right, good afternoon, aloha everyone. Today's proceeding is being broadcast live on the Judiciary's YouTube channel, as well as on Alelo. I'd like to welcome our substitute justices, Judge Jack Tanaki and Judge Shanlin Park. Counselor, are you ready to proceed today? Yeah, all right. Just to confirm, we have 30 minutes allocated for each side. Mr. Cleveland, you're going to start with the 23-minute argument, 7 minutes reserved for rebuttal. We're going to give everyone a 3-minute warning light before they reach the end of their time. Mr. Davis, 15 minutes. Ms. Goldman, 12 minutes, and then you reserve 3 minutes for rebuttal on your cross appeal, I guess. All right. Does that sound about right? Okay, please proceed.
Good afternoon, Chief Justice Rechtenwald and Your Honors. The whole purpose of Chapter 343 is to disclose, analyze, and mitigate impacts. Yet that's exactly what hasn't been done in the EIS at issue here today. The pet industry wants to strip hundreds of thousands of fish from West Hawaii reefs, but has repeatedly swept identifiable impacts under the rug, even after BLNR rejected its first EIS and mandated specific additional information and analysis. The Circuit Court summary judgment ruling should be vacated because the court nullified HEPA's specific mandate to fully address the reasons for prior rejection and nullified the minimum requirements for disclosure and mitigation of impacts, including the cumulative impacts of collection, the direct impacts of concentrated and increased commercial take, and the socioeconomic impacts to the community. As the Supreme Court held in Price v. Obayashi, the only question presented when reviewing EIS sufficiency is whether, as a matter of law, the EIS complies with HEPA's applicable statutory mandates, which include the HEPA rules. The HEPA rules mandate specific requirements for an EIS that's revised after rejection, as in this case. Applying the rules to an EIS does not create a heightened standard. That's a straw man argument put up by the defendants and repeated by the Circuit Court in its ruling, and it misses the point. What the rules do is provide minimum requirements for EISs, including express additional requirements for this specific situation of a rejected EIS. The rules don't allow the applicant to sidestep the reasons for rejection and double down on the same deficiencies as the applicant did here. In other words, a revised EIS isn't reviewed on a blank slate as if it were just any other EIS. There's specific context and specific reasons that the revised EIS must address. And a revised EIS that doesn't fully address the reasons for rejection does not take a hard look at environmental impacts and does not comply with HEPA. The revised EIS rule simply codifies the common sense requirement that an EIS that's been rejected must address the reasons why. The rule specifies that the procedural requirements for a revised EIS are the same as for other EISs, and then says, in addition, the revised EIS shall be evaluated for acceptance on the basis of whether it satisfactorily addresses those reasons. And our arguments under this rule relate to the applicant's failure to provide science-based catch quotas and failure to discuss relevant negative findings. In rejecting the first EIS, BLNR instructed the applicant to analyze the sustainability of its proposed quotas based on lifespan, population size, reproductivity rates, and age at first reproduction. And the revised EIS does not contain the science-based catch quotas.
Let me ask you that, Mr. Cleveland. You know, I think you just quoted part, or what I consider the detail to reason 8 for the BLNR's rejection of the initial EIS. And that was the 2006 paper that talked about the 5 to 25% sustainable take. But, you know, and essentially was saying, well, that's not the best available science. And then it went further and mentioned kind of what you just detailed there. And I'm just wondering if the BLNR had not commented on those details, the lifespans and the sustainability of that level of take and those types of things, would that be required?
Basing take on science would naturally be required for an EIS because that's the kind of information we're trying to adduce. But in this specific situation, we have this additional written finding that provides that detail. And so while the rules would require generally that an EIS would adduce and disclose identifiable environmental impacts, et cetera, the additional detail provided by BLNR in rejecting the initial EIS really laid out specific information that the agency wanted from the applicant.
So is it the BLNR's place or is it this court's place to decide whether a species by species study is required?
That would be the agency's decision, Your Honor, and that is what the agency said. All we're asking the court to do is basically enforce what BLNR told them they needed under this revised EIS rule. Instead of proposing the science-based quotas that BLNR required, the applicant says instead, we're just proposing to take less species. We're basing quotas either on 1% of the West Hawaii population or historical catch, and they say we aren't using the 5 to 25% of population anymore. But on top of being a non-responsive attempt to justify proposed action, really a complete non sequitur from BLNR's directive, the problems with the applicant's new approach are at least twofold. First, for the 2 species with quotas set based on 1% of the population, which is really just their rejected arbitrary methodology with a different number, this still resulted in proposed quotas that are 3 times and 10 times the average historical catch for those species. And the impacts of these significant increases are not discussed or even mentioned in the EIS. DLNR staff even said, it's impossible to determine from the EIS whether population trends could continue under these increases, but then recommended that DLNR accept the EIS anyway and just deal with those impacts at permitting. And that was a legal error. It directly contradicts Chapter 343's mandate to adduce environmental impacts as a condition precedent to approving actions.
One fundamental question I have is how the EIS is supposed to measure impacts. And so how could impacts be measured if the baseline is potentially a depleted baseline because of the catching that had been going on for so many years? Is there anything in the record to establish how long it would take for the fish populations in these areas to return to the original baseline?
No, Your Honor, there is no information on that in this EIS. And in fact, they don't even provide any information on impacts prior to 2000. which I'll expand on in a moment. Just to mention the other species whose quotas were based on historical take, which really just means based on prior market demand, without the analysis of lifespan, the reproductive dynamics that BLNR mandated, there is no way of knowing whether population trends from the last several years could continue for any of the species. And no science saying that what's happened over the last 20 years is an accurate predictor. We could say it's been drizzly for the last 3 days, so it'll be drizzly for the next 3 days, but that's not meteorology. And in the same way, saying we can take this much fish because we've been taking this much fish isn't fish science. The bottom line is, without science-based quotas and analysis that BLNR required, the revised EIS's proposed quotas lack the necessary basis, and BLNR should have rejected it. And then there's the issue of relevant negative findings, which implicates not only the revised EIS rule, but also the applicant's failure to properly address cumulative impacts and the circuit court's improper reliance on appended materials. In rejecting the initial EIS, BLNR called for a discussion of what they termed relevant negative findings, including as an example, a particular study that had been conducted for the specific purpose of evaluating the impacts of aquarium collection in West Hawaii. And that study's conclusion was this: aquarium collectors have significant effects on the abundance of targeted fishes on the Kona coast of Hawaii. During that era, there were 30 to 50 permittees per year in West Hawaii, often taking less fish per year than the trade now proposes for 7 permittees. And even so, the 2003 study found that in the areas where collection was occurring, targeted fish populations were significantly reduced by up to 75% as compared to control sites. These were the relevant negative findings missing from the first EIS and for which BLNR rejected it. It's the leading study and the clearest statement on the environmental impact to fish populations caused by aquarium collection. And you can ask counsel, nowhere in this EIS does the applicant discuss this very relevant negative finding. What they've done instead is come up with various excuses for why it wasn't discussed, and none of them hold up. The EIS tries to summarily dispose of this issue by saying that the Environmental Council found BLNR's reasoning to be arbitrary and capricious. But the Circuit Court vacated that very Environmental Council finding months before the final EIS was published for acceptance. BLNR's authority was the last authority standing. The applicant then further argues that the article is referenced in the EIS itself. Well, yes, but they cherry-picked the study for the pieces they thought were helpful to them and left out the most important part. They didn't address the relevant negative finding about impacts to fish. And in refusing to address these findings, the applicant persists in its refusal to discuss any impacts prior to 2000, even though it's undisputed that collection had been going on for decades already by then. And this directly contravenes HEPA by precluding a valid cumulative impacts analysis, because identifiable past impacts were not disclosed or discussed. And I'll return to that topic shortly. The Circuit Court, for its part, just pointed to passages in the EIS claiming minimal impacts and a comment letter discussing regional population increases as a result of fishery management. But none of these excerpts had anything to do with the relevant negative findings on the issue of reduced populations at collection sites, i.e. the impacts of collection, which is what BLNR and HEPA required. And they skirt the issue yet again by pointing to the copy of the 2003 study attached to the plaintiff's comments and say, but look, it's part of the EIS. And here again, the Circuit Court nullified HEPA's express mandates. The HEPA rules specify that a final EIS must incorporate, reproduce, and provide responses to all substantive information received on the draft. And while the EIS here does provide reproductions of the comments and responds to some of them, that doesn't on its own satisfy the separate requirement to incorporate substantive comments.
When you say incorporate, you mean in the body of the EIS?
That would be the meaning of the word incorporate, Your Honor. I mean, incorporate means to work into the body of something, and reproduce means to just make a copy of it and stick it on the end.
But if there's meaningful response that's provided in the appendix, why isn't that sufficient?
If there are meaningful responses provided in the appendix, that would be one thing, Your Honor, but here often there is not. And again, a prime example of this is this 2003 study concluding that aquarium collection has significant effects.
So is it safe to say then that you would agree if there were, in your view, sufficient comments and responses that it would be okay to do that in the appendix or appendices?
Not entirely, Your Honor, because reproducing and responding to comments doesn't satisfy the requirement to incorporate substantive information. And this goes right along with HEPA's requirement to include responsible opposing views in the EIS.
I mean, but what are appendices? I mean, appendices is an appendix of the EIS. Isn't it part of the EIS?
It is part of the EIS, Your Honor. It's an appendix to the EIS, but simply including comment responses to a comment that has valid substantive information, good science, responsible opposing views. The purpose of the EIS is to state those impacts. And so we would contend that incorporate and reproduce mean separate things.
So if you had taken the exact same responses and comments from the appendix and just put that in the EIS, that would be fine, but it's not fine to have it just in the appendix?
If the response in the comment appendix and the language that was put into the EIS actually disclose the impacts, then yes, that is what HEPA would require. In the case of, for example, this 2003 study, they just reproduced it. Their response in the appendix was just the same one-liner about the Environmental Council, and they certainly did not discuss the relevant negative findings or incorporate any of the substantive analysis into the main discussion of the EIS where it belonged. For missing information on impacts, counsel and the circuit court point to information submitted by plaintiffs. And for additional justifications not discussed in the EIS, they point to comments from trade supporters talking about
what if the revised final said our response is per attachment such and such, pages such and such? Would that be sufficient? We incorporate that as our response.
Your Honor, we contend that incorporating substantive comments is akin to the federal requirement to discuss responsible opposing views and good science in the text of the EIS itself. And so it literally means to work into something already existing so as to form an indistinguishable whole. Appending and attaching a response comment document without analysis of relevant environmental impacts still isn't going to satisfy HEPA.
The 2003 study was which one? Authored by?
Tissot and Hallaker, Your Honor.
Okay, so I'm looking at the circuit court's order, and there's a comment, the RDEIS fails to acknowledge the primary finding of Tissot and Hallaker that 7 of the 10 aquarium fish species surveyed were significantly reduced by collecting. Then there's a fairly long response to that, which doesn't seem to just be parroting the notion that the Environmental Council came to a different conclusion. So is that not a meaningful response that would allow a decision maker to come to a reasoned decision?
The excerpts that the circuit court pointed to in its ruling have nothing to do with the impacts to fish populations at collection sites. They talk about the benefit of management activities in other parts of the coast, and they talk about how regional populations have this increasing trend. But this doesn't address impacts where impacts occur. In the same way, for example, that data on overall increases in human life expectancy say nothing about the impacts of smoking on smokers, background improvements on fish populations on a region-wide basis say nothing about the impacts to the fish populations where the activity is occurring. Again, they just didn't deal with the impacts. And HEPA exists to inform the public, not put the onus on them to disclose impacts. It's undisputable that that burden rests with the applicant. And our contention is that public comments just cannot be used as gap fillers to make up for the EIS's failure to undertake the required analyses. Your Honors, I'd like to also discuss and revisit some of the revised EIS's failures to meet HEPA's content requirements. Returning to the cumulative impacts, again, this EIS sweeps past impacts under the rug. In fact, the EIS claims, rather bluntly, that because the action has been going on since the 1940s, it is part of the environmental baseline. And this is just flat out wrong and directly contradictory to HEPA's mandate to analyze the cumulative impacts of past, present, and reasonably foreseeable future actions. As noted earlier, they refused to analyze any impacts prior to 2000. And they even used that as an excuse, again, to omit the relevant negative finding that by around 2000, the trade had already significantly knocked down targeted fish populations. So the real question is, why not just say it in the EIS? Why not just acknowledge the past impacts? If we all agree that the applicant need not agree with every responsible opposing view, why not just state it in the EIS as required by law? Why try to hide past impacts if not to obscure the true damage collection has caused over time? The question to be answered in any EIS is, how has this action incrementally and cumulatively affected the environment since the action commenced? And the applicant has refused to answer that question. Regarding the trade's tendency to concentrate their catch and select areas, the circuit court misconstrued plaintiff's arguments, but the bottom line is the EIS didn't address the impacts. As written, the revised EIS would allow collectors to concentrate their take and selectively destroy hotspots one by one. An argument boiled down to this: the EIS's proposed quotas apply to the whole West Hawaii coastline. BLNR requires catch reporting by 8 aquarium collection zones. The heat map that we've reproduced on page 29 of our opening brief shows that the trade has tended to concentrate their catch in some AQ zones more than others. And this was data that was submitted by the plaintiffs, but that the EIS did not disclose or discuss or even really respond to, for that matter. The impact of concentrating the proposed quantities of fish in select zones was neither analyzed nor mitigated, such as by establishing zone-based quotas to protect against overfishing. And all the circuit court points to, again, is public comments in support of the EIS, which discuss the benefits of regional management. But again, management data and impact analysis are two completely different things. One cannot substitute for the other.
Do you think that, totally changing the subject, for public trust resource permits, we have required findings. For Native Hawaiian traditional customary rights, we have required findings. But that's been at the permit stage, not, do you think that the EIS needs to discuss public trust issues and or Native Hawaiian kapa'akai type issues within the EIS? Or does that just happen at the permit stage?
Well, obviously, I think the public trust is going to inform what the agency does at every step of the way, and so it should certainly be part of their own analysis of it. HEPA itself requires an analysis of cultural impacts, and this applicant conducted a cultural impact assessment and made some statements about cultural impacts in their EIS. They didn't provide a direct kapa'akai analysis. I think that a kapa'akai analysis would certainly be very helpful in an EIS, since it's an informational document meant to help the agency make decisions, and they've got to process kapa'akai and they've got to process the public trust. So it would certainly be helpful and certainly required to adduce impacts to the cultural environment.
But didn't the RFEIS include cultural impacts? I mean, it talked about Native Hawaiian fishing, recreational diving. I mean, what more needs to be done as far as describing the beliefs and cultural practices.
Yes, Your Honor. I mean, we haven't challenged that in this appeal, and I just wanted to make sure I answered Justice McKenna's question.
Let me ask you about the zone-by-zone assessment. From what I understand, your opponent's position is, well, we could do let's say, take 200,000 yellow tangs from one zone, but it's okay because that will be reseeded at some point. In other words, the fish will come back.
Fish swim around.
Are any of those matters addressed in the EIS?
There are passages in the EIS that talk about the interconnectivity sort of vaguely among fish species and among different areas. But again, it says nothing about the impacts to the fish populations where the collection is occurring at the collection sites. Certainly fish swim around. There's no science in the EIS saying how broadly they swim around or whether, a fish might, are they going to swim from East Hawaii? Are they going to swim from North Kohala? Who knows? I see that my time is up, and I'll just briefly conclude. All in all, Your Honors, this revised EIS fails to state identifiable environmental impacts and is no more than an attempt to rationalize the proposed action and a self-serving recitation of benefits. The exact things the HEPA rules mandate in EIS shall not be. The Circuit Court improperly nullified HEPA's express mandates, and its summary judgment ruling should be vacated. And I'll reserve the remaining time for rebuttal. Thank you.
All right. Thank you, Mr. Cleveland. Mr. Davis.
Thank you, Your Honor, and Your Honors. May it please the Court. Again, I'm Jeff Davis. I represent Pet Industry Joint Advisory Council. Appellant's argument here is facially based on the procedural issues before the Court. Appellant's real goal here is to ban all commercial aquarium fishing. It's a legal activity pursuant to the legislature's decisions to create a licensing plan for this under HRS 18831, which governs commercial aquarium fishing with fine mesh nets. The commercial marine license under HRS 189.2 governs all commercial fishing, including commercial aquarium fishing without a fine mesh net. But what the appellants are really arguing here is that what they call a lack of disclosure. It's differences of opinion about what this EIS should say. The appellants want to dictate the content of the EIS to promote their agenda to ban aquarium fishing. They didn't draft the EIS. The Pet Industry Joint Advisory Council and its consultants did, and it does meet the requirements for an EIS. I think we're all quite familiar with what Price has said about it. Price is goes into a lot of detail. This is a question of law, not fact. Appellants invite you to make a lot of findings of fact in order to try to invalidate this EIS. They ask you to find that a certain article was discussed too much or not enough, that the wrong data was relied on. This is not what the Court did in its prior cases in which it reviewed the sufficiency of an EIS. Price is very instructive. Price A went through the standard, talked about the fact that the Court does not put itself in position to simply put its judgment in place of that of the agency, that the Court does not engage in a fly-specking exercise. Now, the Court has a role, obviously. The Court needs to look at this and make sure that the agency took a, quote, hard look. But if you look at Price's discussion of the sections of the EIS that were challenged there, the Court looked at each one, described the challenge, and then said, this is covered in the EIS. And the EIS was put together in good faith.
Was that based on attachments and not within the body of the EIS?
It was both. Yes, I believe
some of it was in the body, but some of it was in attachments and comments, appendices.
Yes,
correct?
The state's brief actually referenced
How do you
that.
respond to their argument that the law requires that the response actually be in the body of the document?
But that's not what the law requires.
Why not?
Well, in HRS 343.2, the definition of the final environmental impact statement, or the impact statement, the initial statement filed for public review shall be referred to as the draft statement and shall be designated from the final statement which is the document that has incorporated the public's comments and the responses to those comments. Now that's the same word, incorporated.
Incorporated and responds, right?
Right.
But how about the rule that says that once there are reasons given for rejection, you actually have to respond to those reasons?
Well, the EIS does do that. The EIS, I can go through all 14 if you'd like. I have specifics.
In the body of the document?
Yes, at the beginning of the EIS, there's a discussion about what changes were made in response. There's a whole, actually, there's an appendix that describes the changes made in response to the 14 items. And they're addressed throughout. Now, the reality is a number of the concerns voiced by the board were about the lack of limits and the potential for unlimited fishing. And that was broadly addressed by reducing the number of species from 40 to 8 and proposing catch limits for all species, annual total take limits. Okay, those were not in the original EIS. So concerns that are based on those issues are addressed broadly by reducing that. It also reduced the number of proposed permits from 10 to 7.
Mr. Cleveland started out with his remarks basically saying that there really wasn't a species by species study regarding fertility, lifespans, things of that nature, and that's what the BLNR and the initial EIS instructed to be done. And not only that, but there wasn't, and he sort of dovetailed that argument sort of at the end with the zone by zone assessment. And I'm just wondering, listening to your talk about price, how you can make an informed decision with that information.
Well, first of all, in terms of the specific elements that Council mentioned in terms of the species lifespan, population size, reproductivity rates, I will note there are multiple sections throughout the EIS that discuss species by species, and not just for the 8 that remain on the proposed white list, but all 40 that were in the original. It doesn't have all of that information, but the board did not say all of that information is required. The board said, in order to assess the likely impact of the take, the FEIS should adequately analyze the sustainable level of take. The other items were noted as things that are not there. It does not require them. The EIS, as accepted, does adequately analyze the sustainable level of take. The historical take and the science, there is a lot of science and data in this EIS. Reams of data. The the Division of Aquatic Resources has been collecting data for decades now, a little over 2 decades. The West Hawaii Regional Fishery Management Area has a great number of collection points for data. There are other data points. The DAR reports to the legislature every 5 years in a comprehensive report about the West Hawaii Regional Fishery Management Area. There are open areas, there are management areas, and there are closed areas for fishing. And data is taken in many of those areas, and it's reproduced in many tables and in the text of this EIS. So what the board said is that the FEIS should adequately analyze the sustainable level of take. The other items are not listed as requirements, and the EIS does adequately list.
So is it your position that really at this stage, and we're not at the permitting stage yet,
right,
the EIS doesn't need to drill down to that level of granular detail?
Well, the EIS needs to, you have to work with the data you have, for one, and you have to work with, the applicant is preparing an EIS based on, in this case, there were 7 proposed alternatives. It's not an entire universe of options. So, again, we had to work with the data that's available, and these fish, some of them reproduce quite a lot. The data is very clear at historical take levels, which I'm not sure Council was really clear when Council represented that some of them, or that the take levels are 3 to 10 times. That's 1 each of the species in their allegation. The other 6 are clearly at historic levels, and the historic levels, the 8 species that were chosen were species only shown to have stable or increasing populations. So Anything with a decrease in
How
population.
do we know the
was
historic
limited.
levels?
I'm sorry?
We know the historic levels from,
We know the historic levels from the prior 20 years because the catches are required to be reported to DAR, and DAR provided
right,
that
so,
data.
but how do we know the historic levels before the catches started?
Well,
Because it
I'm,
just seems like the baseline is after things were already being taken.
yes, and I haven't come up with a way yet to get
And
data.
there's nothing in the
that-
record to indicate how long it would take for everything to get back to the baseline, the actual baseline, however it might be affected with climate change and things like that, but how long it would take for everything to like fully recover?
I'm not aware of any of that data, and nor has anyone cited any such data, nor has anyone cited data as to what the populations were 70, 80, 90, 100 years ago. I don't believe it exists. And that's not data that can be generated by a new study. So the historical results from the prior 20 years that show stable and increasing populations during periods of active legal aquarium fishing, which is what the data did, is the best available data. There's quite a few.
So that's basically your scientific-based quota to show that the take is sustainable based on the 20-year historic average.
Yes, at the fishing levels, which would not be exceeded under the new proposal, which of course is not binding. It is a proposal.
And your position is essentially, if we were to say, what's the original baseline, that's virtually impossible to do here.
Yes.
You have to use the only data scientifically that you have is the 20-year historic take.
We have to use the available data, I believe appellants are trying to set up a bar that cannot be reached.
An impossible bar, it seems.
Yes, appellant's goal here is to end aquarium fishing. That's not really debatable. They filed a petition with the board that's going to be heard this week to ban aquarium fishing completely. It's not in the record. I can provide it as a supplement. It's brand new, long after we closed briefing. So, again, plaintiffs, appellants are setting up a bar that is far different from what this court has said in Price and Life of the Land versus Ariyoshi and the other EIS cases.
Aside from, I guess, the 20-year historic take or species by species, can you address the argument about the zone by zone assessment not being undertaken to their liking?
Sure. The zone by zone assessment is something that is, first of all, it's a speculative problem in terms of getting to the level of being a problem. I realize they have some data showing some preferred areas, but it doesn't drill down to the specific fishing spots. The fishermen have no incentive, nobody would have any incentive to overfish a spot. Every time they go to a particular spot and take a few fish out, it's less efficient the next time. These are not particularly migratory species. They don't reproduce in a week or two. If you go back over and over, you spend more time to get less results. The fishermen have no incentive to do that, but the DAR, because this is the licenses are issued every year, and in fact can at the DAR or at the board's discretion be revisited earlier. Terms and conditions can be changed, can adjust to changing conditions if they occur. It's not known that they will occur. And again, we're dealing with, instead of a collection of, there were more than 30 licenses in the past regime, this would be 7. There were no limits. There are limits in this proposal. And again, this is a proposal in an informational document. The Pet Industry Joint Advisory Council has no authority to set policy. It can make disclosures to the board, and it can file applications for permits, but the board ultimately has to decide, or the board's designees have to decide what permits to issue and under what conditions, as they do for all kinds of commercial fishing and other activities.
So you're indicating that despite the EIS, the board could still reject the permits?
No, I'm saying the board can regulate the industry. That is their mandate, is to regulate the industry.
So some of the points we've been talking about, the zone by zone assessment, other issues regarding the take, could be addressed at a later stage?
Yes, the EIS is not intended to be the be-all, end-all of information. The cases are replete with situations where new information came out later, and the agency was to take account of that, and that can be in terms and conditions. They can close the open and closed areas do change from time to time.
So while it could be addressed later, I mean, I think their point is that it just wasn't sufficient. There wasn't sufficient information in the EIS to address it now. And your point, from what I gather, is we just have lots and lots of scientific data to give the agency to make their call.
There is a tremendous amount of scientific data in the EIS as accepted, and it is sufficient to allow the board to make decisions concerning commercial aquarium fishing down the road.
Let me ask you this, which is kind of like a fundamental question. Did the board actually make a decision? This was a deemed acceptance situation.
It was a 3-3 vote. The legislature made a decision that every EIS is deemed accepted if it is not affirmatively rejected.
Okay, and that applies to public trust resources. So, gee, I mean, the rule of reason requires a hard look. So basically, the deemed acceptance, and I know that's not what happened here, but the deemed acceptance provision would then allow the board to not do anything and everything would just be accepted.
Well, it would be accepted.
Right, 30 days,
and the legislature
accepted.
made the choice to that's the
Do you think that,
choice.
let me just ask you this, because it's not an issue that's being raised, but do you think that's constitutional?
Yes, I think if the board decided that they would shirk their responsibility on every EIS and just refuse to hear them and let them be accepted, that the board would be shirking its responsibilities, and that would be illegal.
Okay, but you're saying it's a fact-based, and in this case, since it was a 3-3 deemed acceptance.
The board met, the board voted.
And that satisfies the hard look and the application of the rule of reason.
Well, the EIS satisfies the hard look, and the board ensured they took a hard look by, they looked at the original EIS. They said it's not good enough. The Pet Industry Joint Advisory Council revised it dramatically, added a ton of new data, added, again, new provisions, proposing a vast reduction in species, in catch limits, and in reducing the number of permits, as well as many other smaller changes throughout the document. It's much longer. We're talking about a 1,500-page document here total. I do see that my time is up. If
Anything
I may
to
have
wrap up at this point?
a few moments to sum up.
If you'd like to summarize or conclude at this point.
Yeah, as I said, the appellant's position here seeks to basically turn the price standard on its head. They're seeking to impose a burden that simply cannot be met in this case, and to impose a burden that is far above the sufficiency burden enunciated in price. And their position on this would require the court to make factual findings, to be looking at so far as to say, this article's not discussed enough or in the right place. That's not the way the court has analyzed these issues before, and it's not the way the court should analyze it here. They're asking you to make factual findings. That's not the role as defined by this court.
But the problem is that when it's deemed accepted, that's what the environmental court actually ended up doing or had to do, because there really was no acceptance by normal standards.
The problem with deemed accepted
So the burden that then becomes, it is on the judiciary now to analyze it instead of the agency itself.
It is. Well, the agency did analyze it, and 3 of the board members voted that it was acceptable, and 3 voted not to accept. I would posit that they did not vote that it was not sufficient. They voted for other reasons. The problem with the 3-3 vote or the deemed accepted is when the board takes affirmative action, they have to issue reasons, rejection or acceptance. They didn't accept or reject, so they didn't issue reasons for the revised.
And what kinds of reasons do they usually have to provide when it is actually accepted?
The HRS 343 requires them to give reasons.
And that would include cultural impacts?
It's not that specific. It just says, HRS 343-2 says what was required to be in an EIS. It doesn't say what's required to be in the responsible agency's reasons.
Okay.
All right.
Thank you.
Thank you, Mr. Davis. We'll hear from Ms. Goldman next.
Thank you, Your Honors. May it please the court. Deputy Attorney General Goldman for the BLNR and DLNR, collectively the agency. The agency is primarily here today to defend its own actions with respect to the RFEIS document. I'll focus on two key points. The substantive point has to do with upholding the settled law rather than allowing some sort of expansion, as Kaupiko Hui does urge, and demonstrating that the board was not required to reject the RFEIS. The procedural point relates to our cross appeal and argues that requiring agencies to defend the legislatively prescribed outcome of inaction violates this court's precedent in the Helco case, 102 Hawaii 257. I'd like to start with the substance. Kaupiko Hui bases its entire theory of liability on the agency's alleged failure to reject the RFEIS. To the extent the agency is not dismissed as a party defendant in this lawsuit, we maintain our position that rejection of the RFEIS was not required under HIPAA. The circuit court considered sufficiency under the rule of reason, hard look standard from Price v. Obayashi, which everyone agrees applies, and it also correctly interpreted the standard for revised EIS documents from HJR 11-223E, which works to guide the focus of the revised documents. Without altering the foundational standard that's already established by law. This guidance serves HIPAA's goal of reaching a fully informed decision. So it's true the agency has no dog in the fight, so to speak, on the question of whether the RFEIS was sufficient. After all, 3 board members voted that it was, and 3 board members voted that it was not. But there's a statutorily prescribed outcome for that. Under 343(5)(e), the legislature has determined that in the event of no decision after 30 days, an FEIS is automatically accepted. But the legislature also provided a safeguard by allowing judicial review on the merits of any acceptance, whether by default or decision, by original action under HRS 3437. The proper inquiry is whether the EIS was sufficient under HIPAA, not agency culpability where the agency followed the law. So while maintaining that we didn't actually accept the RFEIS, which is a subject I'll return to in a few minutes, and while we are primarily defending our process under the statute, the agency was ordered to remain a defendant in this action, and so we defend the BLNR's process. It was not required to reject. The split vote definitively prevents us from viewing the default acceptance as some sort of agency endorsement or rejection of this document. Nonetheless, as I said, we are a defendant, so we do defend established legal standards from the expansion that Kaupiko Hui urges. The expansion both threatens to heighten requirements for revised EIS documents in a way that would make it unworkable, and it also misunderstands the purpose of public participation in the HIPAA process. Here, there were 4.5 hours of sincere discussion by the board on this revised document. That just shows how much information there was on both sides of the issue. The board members interpreted the information through their own lenses and came up with their own reasoned decisions. Just like a split appellate panel can reach disparate conclusions after working from the same record, the board's split here seems more the result of the board's difficulty reconciling some of the impact predictions, rather than the result of some data deficiency precluding the document from qualifying for acceptance. Now, consistent with the guidance in HAR 11-223E, HIJAC did make significant changes to address the board's prior reasons for non-acceptance of the original EIS, as my colleague has explained. For example, BLNR took issue with the fact that the first version had no catch limits at all on any of the species. The revised version has catch limits on all of the species.
What are those catch limits?
That's a good question. May I come back to that, Your Honor? I should look that up. They're on pages 50 and 52 of docket 91, and they are discussed throughout the RFEIS as well. Thank you. So although the revisions addressing these reasons for the prior non-acceptance might not have been done to the Kaupiko who he's liking, overturning a default acceptance on that basis misconstrues the law and sets an unworkable precedent in a way that could lead to endless revisions and EIS documents never being approved. Now, it's helpful when considering these topics to remember the way that an FEIS is primarily a disclosure document. Its acceptance in no way constitutes an endorsement of the contemplated project. There are additional steps. It's not until the second step, for example, the permitting phase, that we really start focusing on mitigating the likely environmental impacts in light of a specific proposed action, with parameters that can be tailored in light of the information in the EIS. KEPA's first phase, however, is more about flagging the likely environmental impacts to address later when approving actual projects. So in short, the FEIS acceptance is not a substantive determination, and it doesn't mean that, or it's not a substantive determination about a project, and it does not mean a project is going to happen. In Mauna Kea Power Company, for example, 76 Hawaii 259, there was a validly accepted FEIS, but during the permitting process, which concluded no significant impacts, but during the permitting process, opponents of the action produced enough evidence in opposition to rebut the FEIS's conclusion. The board declined to issue the permits, and the applicants who had prepared the EIS sued. This court upheld that denial of permits, notwithstanding the existence of an accepted FEIS.
So you disagree with Mr. Davis's assertion that once the EIS is accepted, it seems like there's no discretion to deny the permit?
With all respect to Mr. Davis, yes, we would disagree with that. The board still has discretion to make an entirely independent decision based on the information in the EIS and additional information should any come forward. So EISs serve as informational tools.
And is it the state's position that at that time, that's when, if a permit were to issue, that's when the public trust and kapa'akai findings would have to be made?
Your Honor, in this situation, in this first phase of the HEPA process, our trustee duties compel an informed process, not a substantive outcome. So whereas here extensive transparent debate results in ambiguity on the question of adequacy, but the legislature has identified a risk from further delays and therefore has provided a default outcome, our trustee role is fulfilled by presenting that nuanced record, not by alleging agency errors where the agency followed the law. Comments and appendices are also included in a HEPA sufficiency determination. EISs serve as informational tools that compile input from all stakeholders. But this purpose is undercut if you exclude information included in the public comments from the sufficiency determination. The key is whether enough information exists to inform decision makers, not who initially provided it. Because an accepted FEIS is essentially a cyclopedia for future decision makers to reference. It reproduces all of the comments. They don't get to pick and choose. Everything has to go in there, and that
So under these circumstances, then it becomes the environmental court's responsibility to go through all the comments and the appendices to decide whether or not the reasons for rejection were adequately responded to pursuant to the administrative rule. I mean, that's what this judge did. This environmental court did that. But how do you respond to the argument that the rule seems to require that the responses actually be included within the body of the document itself for informational purposes, and also to allow the courts to perform its review? I mean, is it going to be our burden to look, how many pages is this? Are all of the...
Those three documents on the end of the table, that's
right.
the EIS.
Is it going to be the environmental court's responsibility to go through the attachments to see if the reasons for rejection were adequately responded to?
Well, that is the situation that the legislature has set up for us. In 2021, they overhauled the entire statute, removing the environmental counsel from the process as an intermediary, thereby placing on the judiciary that burden.
I'm sorry, the overhaul in 2021 had an effect on whether the comments and the response to the comments have to be incorporated in the text? And if so, how?
No, Your Honor. I may have misspoke. The 2021 revisions to the statute modified slightly the role of the courts in this situation because now they are sort of the first line of review rather than having an environmental council decision that the judiciary can work from.
What's your response to the suggestion that the give and take or the response to comments should be in the text of the EIS as opposed to contained in the comments section that's an appendices?
Our response is that no case has ever held that. Every FEIS I personally have researched includes comments in the appendices, and many of them don't discuss those comments in the body themselves because the requirement is to incorporate, not to discuss. Discuss is the federal requirement. So while the RFEIS is not immune from debate, the law doesn't demand perfection. There are arguments, yes.
The federal statute's language is different?
Yes.
It has an additional requirement that our statute does not?
Yes.
Just finish the thought, please.
Yes, under the CFR, which in our briefing we discussed the federal cases that Kaupiko Hui relies on, and we discussed the CFR regulation that specifically governs the comments and the treatment of comments. And in that CFR, there is a requirement of discussion. In our rules, the requirement is incorporation.
But it says 11-200-18 subsection 5 says the text of the final EIS shall be written in a format which allows the reader to easily distinguish changes made to the text of the draft EIS. It doesn't say, it says the text needs to be changed.
Respectfully, Your Honor, we would disagree with that. That rule doesn't say that the text needs to be changed in some way in response to comments.
Easily distinguishes changes made to the text of the draft EIS.
It does say that when there are changes made to the text of the draft EIS, they do need to be apparent in a final version. But an applicant isn't required to discuss every change. So I have an example for that. Oh, I see that I'm getting close to my time, actually.
You can continue your answer.
Okay.
And I'll give you a chance to wrap up at the end.
Thank you. Kaupiko Hui claims the RFEIS doesn't close statewide economic impacts beyond benefits to industry participants. And they base this claim on an article by Sharon Cox. This article assumes 100% loss of tourism in the event that any aquarium collection occurs. But in the EIS itself, in Appendix C, there is a statistic showing that in 2017, the Hawaii tourism industry experienced its sixth record year of growth. That was at a time before Umberger, when aquarium collection was potentially unlimited. So to claim that the applicants had to revise the EIS in a way that takes that flawed conclusion into account is incorrect. And we also note that that study itself is now included in this encyclopedia of information for future decision makers. So while nobody claims that more data down the road during permitting would be unhelpful, the law does not demand exhaustive study of every unknown at this preliminary informational stage. May I have a moment to turn to the procedural?
I think at this point you've gone a bit over, so I would begin to wrap up your argument if you could.
Thank you. So we've been called in this suit to defend the RFEIS acceptance on the merits under penalty of attorney's fees when the agency followed the statute yet did not reach a decision on the merits. For all its guidance on standing for aggrieved parties and the issues that can be raised, HRS 3437 is silent on who should be a defendant in the case of a non-decision. In the absence, in HELCO, This court considered a non-majority agency vote, which resulted in no decision, after which the passage of time caused a default approval of the project under the statute. Writing for a unanimous court, Justice Akoba explained that because HRS 171.5 requires a majority vote for the board to render a decision, the result of a non-majority vote is not an agency decision. The same is true here, where the board deadlocked 3-3 on sufficiency, as HELCO confirms triggering a statutory fallback mechanism that provides for an outcome in the absence of an agency decision is not the equivalent of an agency decision itself. So in the absence of clear direction to the contrary, reading the HELCO case alongside HRS 171.5 and 343.5E dictates.
Do you think a decision needs to be made by the agency then? Because 343.5 also requires that the agency provide reasons for acceptance or not acceptance. And I guess, did you provide reasons saying it's accepted because it was deemed accepted? Is that the reason you provided?
Well, written reasons would have been unworkable in this situation, as there was no decision made by the agency. I'm also I'm familiar with the requirement that stated reasons for non-acceptance must be made. I'm less familiar with a requirement that there must be written.
343.5 does require reasons for acceptance also.
Well, so while we don't disclaim the theoretical possibility that we could ever participate in one of these default actions, the agency followed all laws here, and it only asks for treatment matching the scope of what the board actually decided. Following the law should not be grounds for judgment against the agency. So in closing, we ask this court to affirm the circuit court judgment, but if you are inclined not to affirm, then we respectfully request that you overturn the motion to dismiss ruling because the agency did not accept the RFEIS.
So it seems to me you're arguing, I mean, do you think that this is constitutional then? If you're saying there's really no acceptance, I'm very confused by this whole situation.
This isn't the only example of a default provision under Hawaii law, and we would argue that it's not unconstitutional. There's a policy decision that the legislature made. They could have easily provided for non-acceptance as their default in a situation, but they didn't do so. That's a policy choice that deserves our deference.
And even in the context of favoring depletion of public trust resources, that should be the stance.
Well, again, in this situation, all we're talking about is the acceptance of an informational document that doesn't actually do anything.
So you're saying then it's the next step
Yes.
is the permit application.
You know, like the super ferry, for example. There was an FEIS there that was like, we're going to kill all the whales in the marine life and that's okay. And that was an acceptable FEIS in terms of an adequate disclosure document. But of course, the project didn't happen. The agency did not permit that type of result. We can analogize that to this situation here. And I will avoid using any more time.
Yeah, thank you for your argument. We'll hear from Mr. Cleveland at this point.
Your Honors, I'll try to address at least what seem like the most important arguments that were coming up. With due respect to Mr. Davis's hyperbole, what we're after here is a minimally compliant environmental impact statement that complies with HEPA's statutory and regulatory mandates, which was the holding in price. Mr. Davis mentioned that DAR has decades worth of data in West Hawaii. One of your honors was asking, well, how do you determine the proper baseline in light of these decades of data? And it's pretty simple. The protected areas provide an approximation of natural abundance, and they provide the control group for the evaluation of impacts. That's what the Tissot and Hallaker 2003 study did. And that is a valid scientific method that we all learn in like 4th grade. Mr. Davis also talked about working with the data that you have. They had data about past impacts. They have data going back way before 2000. So what about that data? What about working with the data they had on impacts? Not just the idea of impacts to fish populations, which was what that 2003 study focused on and estimated, but what about the data that DAR has going back to before the 70s? It's reflected. It's in plaintiff's comments. It's not discussed in the EIS. Also, I just really want to draw the line for the court between the idea of stable increasing populations region-wide, standing in for an analysis of impacts where collection occurs. Again, they are apples and oranges at best. Mr. Davis mentioned that they have some data about zone-by-zone collection and that we presented data. It wasn't our data, by the way. This was DAR's data that was included in a study that the plaintiffs attached to their comments. The applicant never addressed this information, never addressed these impacts in the environmental impact statement. I don't think I need to explain this for the court, but permitting is not the second step of Chapter 343 analysis. Environmental review and permitting take place under completely different statutes and through completely different processes. And HEPA's plain language mandates that environmental impacts need to be stated in the EIS as a condition precedent to approving actions, as a condition precedent to permitting decisions, is what that means. HEPA expressly requires both disclosure and mitigation of impacts in the EIS. And an EIS isn't just for the agency's information. It's not an environmental impact clue book for DLNR. It's an environmental impact statement that's designed to inform the public and the agency, and leaving environmental impacts buried in documents appended by public commenters is not the same as fully informing anyone. And as far as the like the EIS and price, they talk about, oh, well, there was studies appended to that. The applicant appended the studies to that EIS. Here it was public comments submitting identifiable environmental impacts to the applicant, and the applicant just turned around and ignored it. Let's see. I think when it comes to how the BLNR handled the decision, the truth is, if BLNR was taking their obligations to take hard looks at EISs seriously, they could have and should have scheduled another meeting before the 30-day period was up to get the full 7-member board to decide whether they wanted to accept or reject the EIS. And they didn't even attempt to do that. In fact, board members on that day sat there and discussed this as if it was already accepted. And it was council that had to correct them and say, it isn't actually accepted till another 30 days from now. The board was 100% on that train.
So under the state's theory of the deemed acceptance, I mean, do you think there could be situations where a state agency can deliberately decide to make deadlocks, decide not to do things, to simply avoid their ability or their duty to then defend the action? I mean, under their theory, it seems like that can happen.
It seems like under their theory, Your Honor, that default acceptances are a get-out-of-jail-free card for the agencies. And frankly, as Justice McKenna's pointed out, there's also public trust principles to be looked at here. The agency does have there's statutory duty. If you look at the plain language of HIPAA, they can only accept an EIS that adequately discusses identifiable environmental impacts. And we've provided a litany of identifiable impacts that are plainly not in the EIS. And this isn't a factual determination.
What about the cultural impacts? The revised EIS, you make the argument that it seems like the initial EIS was premised on an assertion that cultural impacts would occur only if the proposed action would cause a significant decline in the population of a whitelist species considered to be a cultural resource. But the cultural impact statement referred to how for the Hawaiians, there were a lot of people that testified how the trade not only impacts the whitelist species, the depletion, but how it impacts their beliefs, practices, and values. And the revised EIF, the final EIS, did not address these other kinds of cultural impact concerns. Did it? What did it respond to that?
Well, Your Honor, and again, we decided not to go down this road in our appeal, but I do have to say that the cultural impact analysis within the EIS was pretty slapdash and half-hearted. I mean, all they basically said was, well, so many people think that this is a terrible thing to do that we don't think it's possible to know what all the cultural impacts could be. That was their so-called analysis in the revised version. And I think we really just wanted to focus on these issues where they clearly and very plainly did not comply with the plain language under HIPAA and its rules. Your Honors, we respectfully request that the court to reverse the circuit court summary judgment ruling and remand with instruction to grant plaintiffs requested declaratory relief and also to affirm the circuit court's denial of BLNR's motion to dismiss. If the court has any other questions, I'm happy to answer them, but otherwise, thank you.
Thank you very much, Mr. Cleveland. All right. Ms. Goldman, final rebuttal.
Thank you, Your Honors. I'll be brief. So, Justice Eden's question is a good one. We understand the concern that agencies could shirk their responsibilities and exploit uncertainty. But those concerns in the context of this case they ignore the very real facts and the very real efforts that the board actually made. They spent over 4 hours extensively and transparently discussing all sides of the issue, which is precisely what the law compels. Critically, there are no allegations that we violated the statutory process. The board members who sincerely weighed the issues were simply unable to come to a consensus. By providing for default outcomes in the event of indecision, the legislature predicted this kind of uncertainty, and its policy decision was to default to acceptance. Again, they could have chosen to default to non-acceptance. However, they did also leave 343(7) in the law, which allows a merits review of any acceptance.
Is there a difference between a tie, 3-3-4-4, whatever the split might be, and just not deciding in 30 days?
That's an excellent question, Your Honor. I would say under the law, no. The law doesn't require like a hearing, for example. The law would allow for following the letter of the law to simply put it off and let the thing be default accepted. That might be a trust violation, some sort of public trust issue. But that's certainly not the case here, where we have very significant examination of all of the sides and a really genuine attempt to come to a consensus. Just quickly on the point about, they didn't schedule another meeting. So the law allows for the applicant to request an extension of time, not for the agency to just sua sponte give one. And the extension's only 15 days. And I would just point out, this is, I guess, a public record for judicial notice that, we had some terms ending just a few days after this meeting. And so actually there would not have been 7 members on the board had this been sent to the next meeting. It's just unworkable. In this kind of situation, the legislature decided rather than to allow things to atrophy at the agency level, they should move forward. And it also—
Do you know if, because, this is a EIS situation, but there's a lot of EAs. And do you know how often this deemed acceptance thing happens?
Your Honor, I've seen 0 examples of it in any of my research, and I don't believe any of the parties have raised that.
Okay, thank you.
So
We're at the end of your time, so if
Yes.
there's anything to wrap up, and we went over quite a bit before, so at this
Thank
point,
you
if you
so
can,
much. We just ask you to affirm the circuit court's judgment, and if you're inclined not to reverse the motion to dismiss ruling because the agency did not decide to accept the FEIS. Thank you.
thank you very much to all of our attorneys. The court will take this matter under advisement.
Thank you.
E ku iluna, please rise. Ua ho'oku'u ia mai nei ke aha ho'okolokolo ki ike hanohano okumoku aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.